At number 10, we have Aruna Shanbag versus Union of India. Shanbag is a nurse working in an hospital in Mumbai. While she was working there, a man brutally assaulted her, and she went to that permanent vegetative state after that. She suffered permanent vegetativeness for many decades, and after that, the case went before the Supreme Court. Now, the Supreme Court provided for something called as passive euthanasia, which enables quick death by cutting down the lifeline which is being provided to stay alive. This could be one of the mode of mercy killing. Later, after a few years, in Common Cause versus Union of India, the Supreme Court declared that right to die with dignity as a fundamental right under Article 21. Not just this, the Supreme Court introduced something called Advanced Medical Directive. It is also called as Living Will, and Supreme Court has made it as a fundamental right under Indian Constitution. And at number 9, we have Navtej Singh Johar versus Union of India. This is a 2018 case. The Supreme Court invoked a concept called constitutional morality and decriminalized homosexuality. So before this case, there used to be a section in IPC, that is 377, that provided for criminalization of homosexuality. But after this case, section 377 was decriminalized and homosexuality is no more an offense in India. At number 8, we have Vishaka versus State of Rajasthan, 1997. So there was a woman activist. She was working for the government. Her duty is to provide awareness regarding child marriages. She was expressing that child marriage is a menace to our society, and for doing such service in return, she was gang raped by few men in the society. The matter went to the court. The court did not believe that the rape was committed, and the court acquitted all the accused. The reason that was given by the court was a nephew cannot rape any person in the immediate presence of his uncle, and that too in our Indian society. And the court has also raised a question that what the woman's husband was doing when she was being raped. And so after stating all this, the court acquitted all the persons. An NGO called Vishaka approached the Supreme Court, and the court issued guidelines regarding the protection of women from sexual harassment at workplace. And after that, the Parliament came up with POSH Act only as an aftermath to this judgment. And the judgment number 7 is Minerva Mills versus Union of India. Constitution was amended in 1971. The amendment provided that for enforcement of two directive principles of state policy, that is Article 39 Clause C and Article 39 Clause B, if Parliament brings out any new law, and if such new law violates Article 14, 19 and 31, that law will still be held valid, even if it violates certain provisions of the fundamental rights. Which means now two directive principles, that is Article 39C and 39B, is now given primacy over three fundamental rights. In the year 1976, another time the Constitution was amended through 42nd Amendment Act. This time, the situation got even worse. The amendment was made in order to give primacy to all the directive principles of state policy over Article 14, 19 and 31. Before, it was only Article 39 Clause C, 39 Clause B, but now the primacy was given to all the directive principles of state policy. But the Supreme Court did not allow all these amendments and provided that there is a harmonious balance between the fundamental rights and the directive principles of state policy, and that balance should always be maintained. The Supreme Court has also held that judicial review is also part of a basic structure. At 6, we have Indira Sani versus Union of India, 1992. This case is also called as Mandal case. A 9-judge bench of the Supreme Court must decide whether providing 27% of reservation to OBCs is constitutional. The Supreme Court stated that the reservation is constitutional provided that there are 5 conditions in order to make the reservation policy applicable to other backward classes. The first condition is the classes that are going to be benefited from this reservation, they should be socially and educationally backward. The second condition is they should not be adequately represented in the government jobs. The third condition, the concept of creamy layer will be applicable to this reservation policy. And the fourth condition is, while providing this reservation, the efficiency of the administration should not be tampered with in the name of providing reservation. The last and the final condition that has been provided by the court is the reservation in no situation exceed 50%, which means reservation combined to all classes including SEs, STs, OBCs should never exceed 50%, except in exceptional cases. Supreme Court, while providing all these conditions, has also stated that reservation can only be applicable only at the time of recruitment and not for the purpose of giving promotions. The Supreme Court has also stated that reservation cannot be provided for poor because reservation is not a poverty alleviation program. It can only be provided for those who are socially and educationally backward. Next comes the fifth case, that is S.R. Bommai versus Union of India 1994. One of the most overused, abused provision in Indian Constitution is Article 356 that deals with President's rule. In this case, the court stated that federalism and secularism is part of basic structure of Indian Constitution. The governor have to test the confidence of Legislative Assembly only by conducting a floor test, but rather, in this case, the Karnataka Chief Minister was dismissed by the governor on the ground that there is a breakdown of constitutional machinery in the state. The Supreme Court in this case had made a clear distinction between the breakdown of law and order and the breakdown of constitutional machinery in this case. It is also stated that mere breakdown of law and order, the president cannot impose president's rule. Thanks to this judgment, the misuse of Article 356 has been drastically reduced since after this judgment. At number 4, we have K.S. Puttaswamy versus Union of India in 2017. The Supreme Court held that right to privacy is a fundamental right under Indian Constitution. The Aadhaar was challenged in this case under the grounds of privacy infringement. MP Sharma case and Karak Singh case was cited by the government and made their argument that right to privacy is not explicitly mentioned in the Constitution and therefore it is not a fundamental right under Indian Constitution. This was the government's argument, but the judges had other opinions. They stated that right to privacy is a fundamental right under Indian Constitution. It was a 9-0 unanimous verdict. Because of this case, Puttaswamy case, both MP Sharma as well as Karak Singh case were overruled after this. At number 3, we have Shreya Singhal versus Union of India 2015. Parliament amended the Information Technology Act and added Section 66A in 2008. According to this provision, whoever causes annoyance to anybody with the use of digital mode of communication such as texting in using mobile or laptops, etc., that will be treated as a criminal offense. So some students have posted something on their Facebook page and they were booked under this provision for causing annoyance. Shreya Singhal is a law student. She approached the Supreme Court saying that her right to freedom of speech and expression was violated by the state. The court, after considering her argument, struck down the provision of Section 66A of Information Technology Act and held that the provision is unconstitutional as it violated Article 19 Clause 1 Clause A. At number 2, we have Maneka Gandhi versus Union of India. Maneka's passport was seized by the authorities without providing her the valid reason. She approached the court and the court said, in India, we just don't follow the procedure established by law, but also the due process of law. Before this judgment, there used to be a law that bars filing of habeas corpus petition while the nation is under the state of emergency. And this law that bars habeas corpus petitions was challenged in the case called ADM Jabalpur versus Shivkan Shukla. 4 judges in this judgment were of the opinion that in India we follow only the procedure established by law and not the due process of law, which means the court does not question whether a procedure that is provided is fair or not. The court only sees whether the procedure has been followed or not. In simple words to put, the court does not see whether the law is good or bad, it only sees whether it is followed. And this ADM Jabalpur ruling was overruled by this Maneka Gandhi case, and judges stated that because we have Article 14, which advocates for rule against arbitrariness, we follow not just the procedure established by law, but also the due process of law. Supreme Court also interlinked Article 14, 19, and 21 and held it to be a golden triangle of Indian Constitution. So only after this case, it became a rule that while checking a law, it should not only satisfy Article 21, but also Article 14 and 19 as well. And finally, at number 1, we have Keshavananda Bharati versus State of Kerala 1973. The fundamental question in this case was, is the Parliament is supreme that it could amend any provision in the Indian Constitution? The court on 7:6 majority held that Parliament does not have any unlimited power to amend the Constitution. If that was the case, the Parliament could do anything, including rejecting the elections and giving the nation back to the British, etc. and etc. Its amending power is subject to the basic structure of Indian Constitution. And what constitutes under the term basic structure will be decided by the court on day-to-day basis. And that was about the top 10 judgments that, in my opinion, are very important